case before this court is a matter of the state of Ercola versus the state of Bourgogne.
Please be seated. The court welcomes all present to the 37th Jessup International Law Moot Court competition. Over 300 teams have taken part in this competition in various places of the world, some 45 countries. The teams that have survived the competition in various countries and this week in Washington will today meet in the final competition. I call now on counsel for the applicants to address the court. Counsel, please begin.
May it please the court, my name is Lin Lee, and I appear on behalf of the applicant in this case, Ercola. Appearing with me is my co-agent, Ms. Blossom Hing. Your Excellencies, I will be reserving 3 minutes for rebuttal. Your Excellencies, I will be dealing with the issues of self-determination and intervention, and my co-agent, Ms. Hing, will be dealing with the issues of extradition and terrorism. I have 2 submissions to make, Your Excellencies. The first is that the Yitiks do not have a right of self-determination. The second is that Filova has breached the international duty of non-intervention, which gives rise to a duty to make reparation. Now, Your Excellencies, this court is called today to make some very difficult but crucial decisions about the state of the international world order. In light of postmodern tribalism, ethnic minorities do not have a right of self-determination, which gives them a right to secede, especially using violence to do so. Your Excellencies, ethnic minorities do have rights to preserve their ethnicity, but these must be balanced against the interests of the nation and of the global state, the global world order as a whole. Now, Your Excellencies, in the state of Ercola, we have the Yitik minority. They form 22% of the population, and they are scattered throughout Ercola. Now, in 1993, Your Excellencies, there were by-elections held in the province of Westfalen, where the Yitiks are a majority. Now, Your Excellencies, an organization known as the Yitik Liberation Solidarity Association, which I will hereafter refer to as YILSA, submitted a slate of candidates. This was rejected because it contravened Article 19 of Ercola's constitution, because they espoused separatist ideology, which is unconstitutional. Your Excellencies, Filova, a state in the same geographical region, has supported this subversive group and tried to justify its intervention by claiming a right of self-determination for the Yitik people. Your Excellencies, I will then now begin with my first submission, and that is that the Yitiks do not have a right of self-determination. Now, Your Excellencies, the right of self-determination, which we find in the 1960 General Assembly Resolution 1514 on the Declaration of Independence to Colonial Territories, has been basically reproduced in Principle 5 of the 1970 General Assembly Resolution on principles with regard to friendly relations. I will be referring to the 1970 Friendly Relations Declaration. Your Excellencies, this right of self-determination gives a peoples a right to freely determine their political status. And according to paragraph 4, this means that they have the right to establish a sovereign and independent state. In other words, Your Excellencies, the right of self-determination necessarily includes a right of secession. Now, Your Excellencies, the Yitiks do not form a peoples. They are but a minority group, a section of the population within an already independent state. A peoples is an identifiable group, but with a distinct link to a separate territory who are under colonial or alien subjugation. Only in those circumstances, Your Excellencies, would such a peoples have a right to self-determination. As we know, Your Excellencies, the Yitiks are scattered throughout the territory of Ercola. They do not have any distinct link to a separate territory. It is true that in the province of West Furland, the Yitiks are concentrated, they are majority, but this still does not mean that the Yitiks have a land to which they can call their own. They are not a peoples. They do not have a right of self-determination because they are not under colonial domination. In fact, the peoples of Ercola have already exercised their right of self-determination when the continental West European power left and the peoples of Ercola were granted independence in 1960. There is no subsequent right, Your Excellencies, of a section, a minority group within the already independent state to claim a further right of self-determination.
Agent, where do you find the justification of what you just asserted right now before this court? What is the rationale of your argument? Where does this court will find the actual law to give you what you are asking from this court?
Your Excellency, if I may refer you to Principle 5 of the 1970 Friendly Relations Declaration. Now, it describes peoples here. And as we have defined, peoples must have a distinct territorial link. More pertinently, Your Excellency, I will refer you to paragraph 7 of this declaration, which states that nothing in the right of self-determination is to authorize the impairment of territorial integrity. In other words, Your Excellency, after the peoples have gained independence, after decolonization has occurred, there is to be no further right to impair territorial integrity. This, Your Excellencies, I'm referring to the principle of uti possidetis, which is a general principle of international law as established by the Frontier Dispute case.
Counsel, doesn't that principle refer to interstate claims? But is it a principle which does not bear on the question of whether within a state a group may secede?
Now, Your Excellency, it is true that the principle of self-determination was developed in the colonial context. But even in the post-colonial context, this is after a peoples have attained self-determination, have attained independence. The Vienna Declaration of 1993, as well as the 1994 General Assembly Resolution 49151, still hold that the right of self-determination must be limited to peoples with a link to a distinct territory under alien subjugation, colonial domination, or foreign occupation. No further right accrues, Your Excellency, to a minority group within an independent state.
Counsel, can you really maintain that the right of self-determination is one that derives only from the independence movement from colonialism? After all, self-determination first came to the fore as one of President Wilson's particular principles at the time of the Versailles Treaty, when colonialism continued to flourish.
Your Excellency, it is true that self-determination did begin from the colonial context, but there are good reasons why the law has held extremely firmly that these colonial boundaries must remain. Or if they do not remain, Your Excellencies, we are looking at a situation of international instability, of contested borders. For example, Your Excellencies, if we were to say that the peoples of West Furland have a right of self-determination, then the Yitiks in the rest of Ercola would not be given this right. It would have to accrue to the peoples with a distinct link to a territory, which we only know to be Westfurland. If we were to say, then again, if the Yitiks had a right of self-determination, then, Your Excellencies, what of the minority Nicastrians in Westfurland? Would we then say that they too have another right of self-determination and thereon and thereon? Your Excellency, this argument is supported by Professor Higgins, who is a judge of this honorable court, especially, and as well as Professor Frank. This is the argument of infinite divisibility.
Do you think, this court, that we should follow a doctrinal approach to international law as the precedent, as the rule, the norm to be applied by the court?
No, Your Excellency. The words of the 1970 Friendly Relations Declaration are clear, and we must uphold them today because of the rise of postmodern tribalism. We cannot allow ethnic minorities to break away from within independent borders, from within set borders, simply because of their ethnicity. These peoples have no distinct link to the territory. Your Excellencies, there is a small pocket of discretion where the 1970 Declaration has held that, yes, in certain situations, some groups may have a right of self-determination. Now this, if I may draw your attention to paragraph 7 again, occurs when the peoples are not represented with respect to race, color, or creed. Now, Your Excellencies, on the facts of our case, there has been no discrimination of the Yitik people with respect to race, color, or creed. If I may begin with the example, Your Excellencies, that the Yitik people are represented in the government. It is true, Your Excellencies, that YILSA, their organization, was banned. But if I may point out here, Your Excellencies, YILSA, a subversive group, is not to be equated with the Yitiks. There is nothing on the facts to state that the Yitiks have endorsed YILSA as their political mouthpiece. They are simply a subversive group.
May I ask you, Counsel, which of the national liberation movements that we've seen in recent decades have been elected by the people they purport to represent?
Your Excellency, that is a difficult question to answer because you are right in that peoples do not often come forward and endorse these groups unless they are well established, such as the Palestine Liberation Organization. But Your Excellencies, on the facts here, the Yitik people have a right of political representation. They have a right to vote. They have a right to participate in the government. What they do not have is a right to vote in a political party which is separatist. It is because this is banned by Article 19 of our Constitution.
But the right to vote, does not that include the right to put up candidates up for the elections?
Indeed, Your Excellency, and the Yitiks have this right. They can put up any candidates, except, I stress again, Your Excellencies, except that the political party cannot espouse separatist ideology. Your Excellencies, this separatist ideology is unconstitutional, and this is completely consonant with international law, as we can see with the arguments on territorial integrity in the 1970 Friendly Relations Declaration. And there are many constitutions around the world, Your Excellencies, which abhor separatist ideology for the sake of territorial integrity. I can name Australia, Your Excellencies, where they have described their constitution as indissoluble. And the Supreme Court of the United States, Your Excellencies, has again described the United States as an indestructible union.
Chancellor, if I could ask you this question that seems to me to suggest that the right to self-determination exists only where the people claiming the right have a distinct link to a separate territory. It seems to me possible that if a people has a distinct territory under its control, it is already enjoying self-determination. So of what or in what does the right to self-determination consist?
Your Excellency, the right of self-determination is a right for this group of peoples to freely determine their political status. This means that they can choose to secede, to establish an independent nation or to integrate with another nation. This is found in paragraph 4 of Principle 5, describing the modes of self-determination. There is no restriction on what these peoples can do, which is why an ethnic minority, a group of peoples within this definition of peoples, do not have such a right. It would lead to chaos, Your Excellencies. As we know, most nations around the world consist of different ethnic minorities. Are we suggesting then that each and every ethnic minority which can claim a specific ethnicity and culture has a right to break away from the defined borders of their independent nation? No, Your Excellency, this cannot be the case. Now, Your Excellencies, there is another possible exception. Now, in paragraph 5 of Principle 5, even if we are to hold that the Yitiks are a peoples, they can only seek and receive support if they are forcibly deprived of their right of self-determination. Now again, on the facts of our case, Your Excellency, there has been no forcible deprivation of any sort. Perhaps one can turn to the invocation of emergency powers, whereby YILSA was declared an illegal organization. But Your Excellencies, in the first place, I repeat, YILSA is not to be equated with the Yitiks people. The Yitiks, the banning of YILSA does not encroach on the human rights of the Yitiks themselves. Your Excellency, the invocation of emergency powers is generally one of discretion, one of domestic jurisdiction, and is not justiciable before this court, except to the extent that it is done in good faith. Now, Your Excellencies, this invocation of emergency powers was invoked in good faith in light of the bloody and violent street demonstrations which occurred in Westfalen immediately after the decision of the Electoral Committee.
Agent, am I to understand that your government has put out a large, very large number of military, and you have conscription, you have, all kinds of ways to bring young people into this military body. And we have, as evidence before this court, an annex that you may know. And in this annex, I see that you are asking the ethnic group, among other things that may be debatable, but let's focus on one particular item, ethnic group of the person who is filling out this data sheet.
Yes.
So now, how could you explain that this document, done much before, if I understand correctly, the emergency powers that you are claiming now, how do you explain this as being possible under international law?
Your Excellency, you are asking me whether it is legal in international law to ask for a group to state their ethnicity on a form?
And I'm also asking you why your government thought it necessary to do so.
Well, Your
There are
Excellency.
2 questions.
Okay, Your Excellency, now the database is a very complex compilation of military data, and we use it for a variety of purposes. As listed in page 3 of the compromis, we use this data to assign assignments and to make high-level security clearances. Your Excellency, there is nothing in international law. We have not breached international law by requesting that minority groups place their ethnicity. They are not discriminated against. In fact, Your Excellency, in our system of conscription in Ercola, we give extensive vocational and educational benefits to all people serving, which amount to 80% of the population. There is no discrimination. Your Excellencies, if I may move on to my second submission. Thank you. Now, Your Excellencies, Filova has tried to justify its breach of the duty of non-intervention by claiming a right of self-determination for the Yitiks people. We submit that the Yitiks do not have such a right of self-determination. But worse still, Your Excellencies, Filova has breached this international law duty. Now, this duty states that no state has the right to intervene directly or indirectly in the internal or external affairs of another state. Your Excellency, by supporting a subversive group, they are dabbling in the politics of Ercola. And Your Excellency, as I have submitted, this group is subversive because it has espoused separatist ideology, which is unconstitutional in Ercola. Now, Your Excellencies, this is a principle of customary international law, as espoused in the Nicaragua case. And in paragraph 206 of that case, it specifically states that a state shall not support the internal opposition within another state, even if that group's cause is worthy. Where here on the facts we are talking about a subversive group, the cause is definitely not worthy.
Counsel, you keep speaking of a subversive group, but the defendant in this proceeding is the state. How do you make the connection between the subversive group and the state? Because you have to attribute the one to the other.
Indeed, Your Excellency, we are not saying that Filova is responsible for the acts. We are saying that they are responsible in international law because they have gone beyond political, moral, and humanitarian assistance. They have gone beyond that. They have breached the principle of non-intervention. And I have 4 facts to show how they have gone beyond those limits by supporting this organization. The first fact, Your Excellency, is that a communique, the 6th communique, was sent from the territory of Ercola. And this communique, Your Excellency, was sent from the Filovan Intelligence Service Center itself. Secondly, Your Excellency, Filova has not denied its involvement. It has admitted to it in page 11 of the compromis. In fact, it is only trying to justify its involvement. Now, Your Excellencies, in the respondent's memorial, they have claimed that Filova has a right to use force in intervention. And we strongly disagree with this reading of the law. There is no international right to use force. As I've already said, the limits are political, moral, and humanitarian assistance. And they have definitely gone beyond the bounds of humanitarian assistance, which merely include provision of food and medicines and clothes. Your Excellencies, the third fact is that in the first communique, it was stated that Filova had aided, its intelligence service had aided in the cracking of the Esprit database. And they said that another communique would be sent from Filovan soil. And this was evidenced by the 6th communique. And lastly, Your Excellencies, more breaches of private of law occurred when packages were sent from a Filovan source. All these facts, Your Excellencies, lead inextricably to the one conclusion that Filova has interfered. Your Excellencies, I take the Corfu Channel case where it says that we must draw reasonable inferences from these facts linked together to draw that conclusion. Your Excellencies, if I may move on to my final submission, Filova has breached international law. It has breached the duty of non-intervention, and therefore it owes another international law obligation, and this is to make reparations. Now, Your Excellencies, we ask for the return of the Esprit database as well as damages for the cost of a new encryption code. And this is evidenced by the Chorzao factory case, where we may be put back in the position where we were before the breach. Secondly, Your Excellencies, I see my time is up. May I summarize my last submission?
Yes, please.
Yes, Your Excellency. And furthermore, we ask for damages for direct and indirect injury to the state of Ercola to be measured by the loss of privacy to the 204 Ercolan citizens. Your Excellencies, thank you.
Thank you so much, Counsel.
May it please the court, my name is Blossom Heng, and I appear as co-agent for the state of Ercola. I shall be dealing with 2 issues, terrorism and extradition. From London to Colombo to New York City, the World Trade Center there. Terrorism presents one of the greatest threats to international peace and security. Today, this court in granting the reliefs that Ercola seeks, will be giving effect to the universal condemnation of terrorism. The relief that Ercola seeks is twofold. First, a declaration that Filova has breached international law in its refusal to declare ILSA illegal because ILSA is a terrorist organization. Secondly, that Filova immediately extradite the 4 ILSA prisoners in its custody back to Ercola. Moving on to my first submission of terrorism. Ercola has requested that Filova declares ILSA illegal. Filova has refused to do so, and we submit that in its refusal, Filova has breached international law. The definition of terrorism, Your Excellencies, we submit that there are 4 crucial elements. These are criminal acts intended or calculated to provoke a state of terror in the general public, and lastly, for political purposes. This definition can be found in the General Assembly Resolution 4960 on the Declaration on Measures to Eliminate International Terrorism. This declaration was passed in 1994 and was adopted without a vote. Your Excellencies, all 185 states in the General Assembly has recognized this definition of terrorism, and we submit that ILSA is a terrorist organization.
Counsel, is there anything in that declaration that obliges a foreign state to declare illegal under its law a foreign terrorist movement, assuming arguendo that this movement is such?
Your Excellencies, no. However, there is a general duty, a legal obligation in international law today that states must cooperate to suppress terrorism. And this can be found in the same declaration. It can also be found in the 1985 Declaration Against Terrorism, in the 1993 Resolution of Human Rights and Terrorism. All these 3 resolutions, which were all adopted without dissent, state, express that states must come together, condemn, eliminate terrorism. This is the duty in international law. And we submit that the most effective way and the simplest way, in fact, for Filova to comply with this duty, to discharge this duty, is to declare ILSA illegal. In doing so, it will prevent ILSA from carrying out further terrorist acts from Filovan territory. It is undisputed that elements of ILSA which is banned in Ercola has reached Filovan territory. We infer from the facts that Ercola and Filova are proximate, even if they are not joined by a land border. And we are worried, Your Excellencies, that further acts of terrorism will be carried out from their territory on our citizens. As the facts stand, Your Excellencies, our citizens' lives have been taken. ILSA's bomb attacks on the stock exchange, in the train stations, have taken civilian lives, have taken the lives of 4 policemen. They have caused massive property destruction. Our citizens are in fear. They do not know when they can step into a train station, step on a public road that is next to a stock exchange, and not be blown up. We therefore require that Filova declares ILSA illegal, so that ILSA cannot operate from Filovan territory, so that at least it will guarantee us some measure of safety. This is the way for Filova to carry out its obligation in international law to cooperate to suppress terrorism.
Counsel, you've cited 3 General Assembly resolutions as the source
Yes, Your
of the
Excellency.
alleged legal duty. Are General Assembly resolutions constitutive of international law? Are they lawmaking?
Your Excellencies, General Assembly resolutions in itself are not legally binding. However, in the Nicaragua case, this court, at paragraph 188, has stated that where there is sufficient state practice and opinion juris, a General Assembly resolution can become customary international law. And we submit that on the strength of 3 resolutions adopted all without dissent, this constitutes customary international law. In fact, this has been further supported most recently in 1996 at the Peacemakers Summit in Egypt. In that summit, we recognized that not all states were present. In fact, only 31 states were present. However, the states that are most particularly affected by terrorist acts, either because they have in the past supported it or because they have also suffered under terrorist attacks, these states, for example, the United States of America, for example, Egypt, Qatar, Kuwait, United Arab Emirates, all these countries have come together to condemn terrorism, that whatever the motivation, whoever the perpetrators, terrorist acts must be eliminated. And this, we submit, is evidence, is clear evidence, Your Excellencies, of customary international law, of this legal obligation in international law to suppress terrorism. We translate this obligation, or we ask this court to translate, to interpret this obligation, and hold that Filova must declare ILSA illegal to carry out this obligation.
Are you suggesting to this court agent that if we cannot find the norm in international law that is already created, this court has the power to create an international law norm?
Your Excellencies, may I ask which international law norm? Is it to suppress terrorism?
That's what you are saying.
Yes, Your Excellencies. Indeed, this court does look to previous precedents, does look to state practice, as in Article 38 of the statute of this court. However, this court can create law. It can create law especially when it is shown that states have united to condemn terrorism. And this court must create law to give effect to that condemnation of terrorism. But as my submission has been, Your Excellency, is that there is already in existence this customarily international law duty and obligation on states to suppress terrorism. And we ask this court to apply that duty to Filova and hold that it has indeed breached international law in its refusal to declare ILSA illegal.
Counsel, do you have facts other than the ones recounted a moment ago by your colleague to support the proposition that what you characterize as terrorism is in fact operating from the territory of Filova?
Your Excellencies, our case is not that Filova is responsible for state-sponsored terrorism. We are not saying that ILSA has carried out terrorist attacks. The bomb attacks on the train station and stock exchange were carried out from Filovan territory. Our case, it is not supported on the facts if that was our case. Our case is that wherever these terrorist attacks have occurred, the fact of the matter is ILSA or elements of ILSA have gone into Filova. And therefore, Filova must declare ILSA illegal. Are there further questions, Your Excellency?
I understand. Your position seems to be that what Filova should do to fulfill its duty to stamp out terrorism
Yes.
is something that it should do when perpetrators of terrorist acts in Ercola arrive in Filova.
Yes, Your Excellency. I shall move on to my second submission.
That suggests that your first submission essentially is the same as your second submission. Your second submission being
Extradition.
They should be either prosecuted or extradited.
Your Excellencies, we recognize that there is no duty in international law to extradite or prosecute. That duty is created by treaty, for example, the Montreal Convention on Civil Aviation, and there is no such treaty on our facts. However, what we have is an extradition treaty between Ercola and Filova. We submit that this extradition treaty applies because the dual criminality principle contained in Clause 12 of this treaty is satisfied. Filova has attempted or has indeed already invoked the political offense exception to refuse extradition, and we submit that Filova cannot do that. The political offense exception in Clause 5E of the treaty cannot be applied. It cannot be applied to terrorists. Your Excellencies, a treaty must be interpreted in good faith. This is according to Article 26 and 31 of the Vienna Convention of the Law of Treaties in 1969, to which both the state of Ercola and Filova are parties to, and therefore we are both bound by that. And we submit that Filova cannot interpret the treaty and invoke the political offense exception in good faith if it uses that to shield terrorists. In Article 31(3)(c) of the Vienna Convention, it states that to interpret a treaty in good faith, one of the factors to be taken into account is the general state, is the relevant rules of international law applicable in the relations between the parties. And we submit that a relevant rule of international law today, or in 1993, at the time where the treaty was interpreted, is that states must suppress terrorists. Indeed, to suppress terrorists means not to let them go unpunished, not to use what treaty you have before you and use that to shield terrorists. And then,
Counsel, isn't there a good deal of state practice to treat acts of terrorism with a clear political motivation as being within the political offense exception?
yes, Your Excellencies, in the past, there were cases, for example, Inri McMullen, Inri McKin, where states have indeed not extradited terrorists. And we also recognize that it is within the discretion of each state to determine what is a political offense. And this can be seen by the fact that there are at least 3 tests in international law today as to what constitutes a political offense. But we submit that whilst a state can exercise its discretion to determine what is a political offense, it must do so in good faith. And in good faith means that the state must take into account the general state of law at the time of interpretation. This is according to Article 31(3)(c) of the Vienna Convention. The general state of law in 1993, when Filova interpreted the treaty, when Filova invoked the political offense exception, is that states are unequivocally against terrorists, and states see and hold and realize that they must punish terrorists, or else a state like Filova can simply invoke the exception, shield the terrorists, and hold the rest of the world at ransom. Your Excellencies, this cannot be the case, and we pray that this court would ask for the extradition of these prisoners back to Ercola for punishment of their abhorrent crimes in Ercola. In any case, Your Excellencies, the rationale of the political offense exception prevents it from being used to shield terrorists. This exception arose out of the American and French Revolution to protect political activists from a tyrannical regime, to protect...
Agent, I understand from the facts before this court, and correct me if I'm wrong, that these terrorists, quote unquote, are in fact under some arrest in Filova, and they have been brought to court. So wouldn't that be considered as sufficient in terms of Filova's obligations under international law?
Your Excellencies, these terrorists are in administrative detention. They are charged for paltry misdemeanor offenses where they are where the imprisonment is not more than 1 year. Your Excellencies, these terrorists have taken civilian lives of people who have deserved nothing, have done nothing to deserve being blown up.
Are you arguing that in fact Filova has a duty to tailor its criminal law the way you want it to be tailored?
Your Excellencies, no. That would be indeed be intervening into Filova's affairs, and we do not intend to do that. In fact, Filova can prosecute these terrorists for the misdemeanor firearms offenses, but we require that they be returned to Ercola first for the prosecution of the abhorrent acts in Ercola. Be prosecuted for that first, and then, if necessary, we will return them to Filova and let them serve out the rest of their sentence. The double jeopardy rule will not be jeopardized in this way because it is for different offenses that they are being punished for, Your Excellency. Returning to my point that the political offense exception, the rationale of this exception, cannot be used to shield terrorists, our submission, Your Excellency, is that terrorism is not democratic. Terrorism is to use violent means to impose your own political agenda on an unwilling and terrified public. And this is what the 4 ILSA prisoners have done. Therefore, that exception, the whole rationale, the whole noble rationale behind the exception, prevents it from being used to shield terrorists, to shield perpetrators of the most abhorrent crimes in international law today.
Could I ask you this question? As I understand it, in connection with your submission, the relief requested for the gravamen of the offense is failure to extradite and failure to have declared ILSA illegal. What would follow, or what is implied in the declaration of ILSA as being illegal? What is then to be achieved? What proceeds from that?
Well, firstly, the declaration is not that this court should force Filova to declare ILSA illegal, because Filova has already refused to do so when Ercola requested it to do so. A declaration is for this court to acknowledge that Filova has breached international law in its refusal to declare ILSA illegal. If this court should hold that, it would show that the court has joined or has given effect to these legal instruments, to the General Assembly resolutions of states to condemn terrorism and to suppress terrorism. Furthermore, it will also mean that ILSA cannot operate from Filovan territory and thereby guarantee Ercola some measure of safety, at least, against our own citizens who have turned against other citizens in our country. Indeed, Your Excellency, state practice has shown that the political offense exception cannot apply to terrorists. In the case of Inri Atta, for example, a case of the United States Court of Appeal, Second Circuit in 1989, a terrorist, a Palestinian terrorist who blew up a bus in Israel, came to America. He was extradited back to Palestine.
Are you saying to this court that we should apply U.S. law?
No, Your Excellencies. This is the International Court of Justice, and it will apply international law as it sees fit. However, this can constitute, or domestic law can constitute a general principle of law where many courts in many countries of the world follow the same principle. And under Article 38 of the statute of this court would look to that. In any case, this also shows state practice, and again, is a source of law to which this court will look towards.
The case you're referring to probably dealt with an extradition treaty and a political offense exception, which you applied by analogy here, isn't it?
Indeed, Your Excellency, there was an extradition treaty, and the political offense exception was not invoked because it was a terrorist in that case. He was therefore extradited. And we ask that this court would also order Filova to immediately extradite these terrorists back to Ercola for the lawful prosecution of their crimes. Your Excellencies, we also recognize that in 1985, the United States and the United Kingdom have entered into a supplementary treaty to specifically state that the political offense exception does not apply to terrorists. However, and we note that on the facts, there is no such treaty between Ercola and Filova. But we ask that this court does not hold that against us. We submit that 1985 treaty only makes it clear that the political offense exception cannot apply to terrorists. It is not mandatory that there must be such a treaty before the court can hold that the political offense exception does not apply. That treaty is to explicitly state that it does not apply to terrorists only. I see that my time is up, Your Excellencies. Thank you very much.
Thank you, Counsel. May we now hear counsel for the respondent.
Mr. President, members of the court, my name is Matthew McLennan, and I appear with my co-agent, Mr. Kramer, for the respondent state, Filova. Your Excellencies, this case concerns one of the essential principles of modern international law, the right of peoples to self-determination. Upon the outcome of this case depends not only the future efficacy of that right, but also the future of the Itik culture in Ercola. Accordingly, I will address Filova's involvement with ILSA, submitting first that Filova has not violated the principle of non-intervention. Second, that even if Filova has intervened in the affairs of Ercola, this intervention can be justified. Thirdly, that Filova is under no duty to ban ILSA. And finally, that Ercola has violated the Itik's minority rights. My co-agent, Mr. Kramer, will address the question of extradition, privacy rights, the retention of the Esprit database, and also the question of damages. If I may turn then to my first submission, which is that Filova has not violated the principle of non-intervention. In order to establish that Filova has violated the principle, Ercola must establish first that a legal support has been given to ILSA, and secondly, that Filova is responsible for the provision of that support. Filova submits that there is inadequate evidence to satisfy the second requirement, that there is too much uncertainty surrounding these facts to hold Filova responsible. Agents for the applicant relied upon circumstantial evidence, and they correctly referred to the Corfu Channel case for the authority that they could do so. However, in that case, this court also held that when inferences of fact were drawn, those inferences must leave no room for reasonable doubt. Filova submits that Ercola has failed to satisfy that burden of proof.
Counsel, could I ask, what is the standard of proof that you must meet in order to carry the burden on that, or to satisfy us of the truth of that proposition?
The proposition in law, or in
the factual proposition you're stating, there isn't sufficient proof to find
certainly
the respondent liable. What is the standard of proof?
In order to show that Filova is responsible for the acts which they've alleged we are, Ercola must establish that state responsibility is invocable in accordance with Article 10 of the ILC's draft articles on state responsibility, which provides that Filova will be responsible for the acts of its officials if they've acted in accordance with orders or they've acted in an official capacity. In respect of each of the main allegations which Ercola has made, there is insufficient evidence to satisfy this requirement. For example, in relation to the pamphlets sent to the Ercolan citizens. These pamphlets were sent at a time when there are only 2 copies of the Esprit database in existence, and that could point towards Filovan responsibility. However, we know that ILSA possessed the pamphlets for 3 months before they were handed over to Filova. Accordingly, it's quite conceivable that they downloaded this information from the database and then sent it to Ercolan citizens themselves. Furthermore, there is absolute...
But isn't that hypothetical? Do we have due evidence in front of this court about what you are just saying now?
It is submitted that the question is not whether or not there is positive evidence to support the alternative view, rather that in view of the doubts that surround the allegations made by Ercola, it remains possible that there is an alternative explanation, and in accordance with that explanation, Filova is not responsible. Most significant is the fact in relation to these pamphlets that we do not know anything about the sender of these pamphlets, nor from exactly where they came. All we know is that they came from Filovan territory. That's not enough to fix Filova with responsibility.
Counsel, do you accept that the cracking of the code was carried out by Filovan intelligence, or do you think that's in controversy?
This is probably the strongest allegation made by Ercola. The difficulty is that we do not know very much about the circumstances in which any agents of the Filovan Intelligence Service may have been involved. We do not know whether they are not, there's certainly no evidence that they're acting in accordance with orders, and we do not know whether in the circumstances in which that support was given, they were acting in an official capacity. And in terms of acting in official capacity, that has been held to require either that they had an ostensible authority to do what they did, or that they were using means which have been put at their disposal by the state. Either of those 2 elements cannot be proven on these facts.
Has the cracking of the code been repudiated by the government you represent?
No, it is not. If I may turn then to my second submission, and this is that even if the court finds that Filova has intervened in the affairs of Ercola, this intervention can be justified by the principle of self-determination. In order to establish this justification, Filova will first establish that the Itiks of Ercola do have a right to self-determination, and that secondly, that Filova has a right to assist the Itiks in their struggle for self-determination. Last year, in the East Timor case, this court described the right to self-determination as one of the essential principles of international law. The submissions of the applicant, however, threatened to render self-determination a dead letter by limiting it to cases of decolonization at a time when the decolonization era is all but over. Filova submits that the better view is that colonialism is just one instance of a general concept of alien domination. We further submit that the existence of alien domination is indicated by the degrees to which the subject people are ethnically distinct, occupy a geographically separate region, and are subject to some degree of misgovernment, exploitation, and abuse. The Itiks are clearly ethnically distinct. There is, however, some doubt about the extent to which they occupy a geographically separate region. Agents for Ercola submitted that they were scattered throughout the territory of Ercola. Filova submits that this view is not supportable on the facts. We know that the Itiks constitute a majority in West Furland, and we also know from page 4 of the compromise that they constitute in a number of other provinces in Ercola. It is further submitted that although this cannot be ascertained with absolute certainty, it is reasonable to assume that these provinces are contiguous. The reason for this is that ethnic groups tend to occupy an historical space, and this would explain why, although they're a minority in Ercola as a whole, the Itiks managed to constitute a majority in a number of provinces. And the final, and perhaps the most important ingredient in establishing that fact that alien domination exists, is the existence of some degree of misgovernment, exploitation, or abuse. In interpreting General Assembly Resolution 2625, the Declaration on Friendly Relations, agents for the applicant submitted that it was sufficient that Ercola had a representative government, and it seemed by that they meant it was enough that Itiks had a right to vote. Filova submits that the General Assembly in that declaration must have meant something other than the right to vote in a democratic election, that the nature of democracy is such that they inevitably work in favour of majorities in preference to that of minorities, and that when you have a divided society such as Ercola, where you have two very large groups who have different language and different culture, and it appears occupy different territories, the inevitable result of that situation is that the smaller group does not enjoy the same rights as the others. And that view is supported by the history of ethnic relations in...
I'm sorry to interrupt, but I have a difficulty following your argument. Are you standing before this court in some kind of protection or some kind of vocal advocate of the Itik people? Is that what you are when you are in front of us?
We are defending our own behaviour, which has been impugned in this court. The right of the Itiks to self-determination is relevant to our ability to defend our behaviour. If it is found that they do have a right to self-determination, then it is submitted that we do have grounds to intervene in the affairs of Ercola. If I may address another element of the policy arguments put by agents for Ercola in relation to self-determination, they invoke the spectre of infinite divisibility of states and threaten that perhaps a great era of political instability would follow from a broader right to self-determination, which is what, of course, is being advocated by Filova. It's submitted these submissions present the court with a choice, and that choice is what path leads to greater peace? Is it the promotion of self-determination of peoples, or is it the preservation of the status quo? Article 1, paragraph 2 of the United Nations Charter provides that one of the purposes of the United Nations is to promote friendly relations based on the self-determination of peoples. And Filova submits that this is a cogent reason why a broader view of self-determination is acceptable, because there is a greater hope for providing peace and stability in recognizing and addressing the concerns of ethnic groups such as the Itiks, rather than ignoring them in the name of state sovereignty. The second element that must be established in this submission is that Filova has a right to assist the Itiks in their struggle for self-determination. Filova submits that this right has been developed by state practice in two arenas. First, in the General Assembly. In the Declaration on Friendly Relations, the General Assembly declared that states have a duty to promote through joint and separate action the realization of the right of self-determination of peoples. And similarly, in Article 7 of General Assembly Resolution 3314, the definition of aggression, the General Assembly stated that peoples subject to alien domination have a right to seek and receive support in their struggle for self-determination.
Well, does that support include the right to harbor, if that is the case, the people who bombed the stock exchange?
It's submitted that this is a matter which I'd actually address in greater length in my third submission. However, just briefly, it would be our contention that there is no evidence to say that the bombings were prepared or organized in Filovan territory, or that Filova did or could have known that that was the case.
So the answer to the question is no.
Yes, Your Excellency.
Okay.
In addition to these General Assembly resolutions, there has been quite a deal of state practice in which national liberation movements like ILSA, which have used force, have been recognized as legitimate by states. If I may refer the court to the example of the PAIGC in Guinea-Bissau, which declared itself independent of Portugal and was recognized by 84 states. Similarly, the Polisario movement in Western Sahara is not only a member of the Organization of African Unity, but it has been recognized by 54 states. Similarly, the PLO was granted observer status of the United Nations, as was SWAPO and the ANC, and organizations such as the Eritrean People's Liberation Front and the Sudan People's Liberation Movement all received support from states in their struggle for self-determination. Agents for the applicant invoked the decision of this court in the Nicaragua case for the proposition that on no basis could a state intervene in support of an opposition within another state's territory. However, it appears from paragraph 206 of the court's decision that decolonization cases are a separate case and occupy a special category. Of course, we don't have a decolonization case here. However, it's submitted that the point is the same, and that is when self-determination is involved, the situation is different. And the reason for that is that intervention is not relating here to a matter within the sovereign discretion of the victim state, but that the intervention is in relation to the state's international obligations, and that all that Filova is trying to do is help the Itiks realize their right to self-determination and hold Ercola responsible for its refusal to recognize that internationally recognized right. Agents for the applicant also argued that democratic endorsement was required for a national liberation movement to be recognized. There does not seem to be any state practice supporting this proposition, and the reason for it is quite clear. States like Ercola are not about to allow ILSA to conduct referenda to determine whether or not they're allowed to represent the particular people. Finally, in relation to this issue, agents for the applicant referred to General Assembly Resolution 2625 for authority for the proposition that the Itiks could only use force in their struggle for self-determination after they were subject to some forcible action by Ercola. In this court, in the Namibia opinion, Vice President Moon affirmed the right of the Namibians to use force in their struggle for self-determination. But the only actions by South Africa to which the judge referred was the fact that it had blocked the Namibians' path to independence. It seems then that it's merely denying the right to self-determination is sufficient degree of forcible action to activate a right to use force. In any event, Ercola has done far more. Not only have they banned ILSA and imprisoned some of its members, but they have an article in their constitution which forbids anybody from even talking about separatism in their political system.
Counsel, would you not concede that if state aid arrogates to itself the right to evaluate the politics of state B, and if it makes the judgment that those politics amount to denial of self-determination, the consequence that it can render armed assistance to a minority in that state, the way is open to unbridled interventionism, collapse of international order.
Certainly there's always going to be a risk that the right to self-determination will be exploited in order to make unjustified interventions. However, it's submitted that if the right is clear enough and clearly enunciated by this court, then the possibilities of that happening are limited. Furthermore, in the particular case with which we're concerned, it's sufficient that the court decides that there is a right to self-determination, that if the court disagrees with Filova's actions, then if the court disagrees with Filova's interpretation of the edict's right to self-determination, then we must concede that our intervention cannot be justified. General Assembly resolutions are insufficient in themselves to create a rule of international law. Furthermore, there is no state practice in this area actually banning terrorist organizations. There are many, many declarations by states condemning terrorist organizations, but there are none of states banning terrorist organizations. And even in the most recent Cairo conference, which was referred to by agents for the applicant, although the international community gathered to condemn terrorist organizations, they did not make any mention at all of Iran and Iran's support for the terrorist organization Hamas. Finally, in relation to agents for the applicant's submission that this court can create international law, it is submitted that in accordance with Article 38(1) of its statute, this court may only decide what international law is and may not create it by itself. Furthermore, just briefly, it is submitted that even if such a duty to ban terrorist organizations existed, there is no evidence that such a duty has been violated by Filova. This is because...
Are you saying that if this court, in deciding this case, cannot find any treaty law, any hard law, then we are prevented from creating the norm that would be applicable to this particular case? Is that what you just said?
The court is not limited to finding norms of international law based on treaty or hard law. The court can look to other sources of international law, most primarily state practice. However, it's submitted that the agents for the applicant have not produced any in this court and that none exists in this particular area.
And are you saying that a state practice cannot be inferred from the fact that a number of states have gathered a number of times to condemn terrorist actions and terrorist groups?
The court could infer that there is a rule that states must condemn terrorism. However, unless states have actually banned terrorist organizations, then it does not appear to be any state practice to that effect. Furthermore, briefly on the question of whether or not Filova has violated the duty, there is no evidence that Filova knew or could have known that ILSA was operating from within its territory. Ercola has not been able to stop the terrorist acts. There doesn't seem to be any reason why Filova should be able to either. And when this court, in the Corfu Channel case, was discussing the due diligence obligations of Albania, the court there was concerned with a situation where Albania was responsible for the supervision of the Corfu Channel, which was a strip of water along the coast of which it had many observation platforms. There are no such observation platforms for watching over terrorist activities. If I may turn then to my fourth submission, which is that Ercola has violated the ETIC's minority rights. Filova submits that Ercola's language law, which prohibits the use of ETIC in public business, and the employment practice, which refuses to provide paid leave to ETICs, violates customary international law. I'll address each of these violations in turn. First, the language law. Customary international law recognizes the existence of minority rights and a corresponding duty on states to take positive steps to preserve the minority's distinctive characteristics. This duty has appeared not only in Article 27 of the International Covenant on Civil and Political Rights, in the 1992 General Assembly resolution on the rights of persons belonging to minorities, but also respect for minorities was included in the European Community's guidelines on recognition of states in Eastern Europe and the former Soviet Union. In response to these minority rights, state practice has been, in those countries where there are a few popularly spoken languages, and especially where minorities are concentrated in particular regions, then the state practice has been to recognize minority languages as official. If I may refer the court to the Constitution of Sri Lanka, which in Article 22 provides that Tamil shall be the official language in Tamil areas. The Spanish Constitution and the Belgian Constitution also provide for recognition of minority languages. And the Indian Constitution, in Article 347, provides that the President shall declare a minority language to be official when it is the language used by a substantial proportion of the population of the territory. Furthermore, there are some number of municipal laws providing support to minority languages. If I may refer the court to the Maori Language Act in New Zealand, which provides, among other things, that Maori must be available to be taught in schools. Similarly, the Autonomy Statute of the Basque Country and the Greenland Home Rule Act provide recognition to minority languages. Agents for the applicant sought to invoke administrative expediency as a justification for Ercola's failure to recognise minority languages as official. We concede that there is a cost in recognising minority languages. However, it is a cost which the international community expects states like Ercola, to incur when they have a large number of their population who are concentrated in a particular region and who are speaking a different language to the majority. Turn then to the question of the employment practice and its refusal to provide paid leave. Filova submits that Ercola's failure to provide paid leave is in breach of its obligation to promote the ITIC's religious practices. And the better practice which the court should look to is that which has been adopted by Sri Lanka, which provides public holidays for all 4 major religions, Malaysia, whose holiday ordinance schedule provides for 11 public holidays, including holidays for all the major religions, and again in Pakistan, where religious holidays are available for all 18 religious holidays are provided for all major religions. If there are no further questions, that concludes my submissions.
Thank you very much, There may be some seats over here. Please, sit.
Mr. President and members of the court, as my co-agent stated, I'll be making 3 submissions in the areas of extradition, the Esprit database and privacy. The first is that Filova is not obliged to extradite the ILSA offenders. The second is that Filova is under no obligation to compensate Ercola with damages for harm allegedly suffered, including an alleged breach of a customary international law right to privacy. And the third submission is that Filova is under no obligation to return the Esprit database. Turning to my first submission with respect to extradition. Your Excellencies, Filova seeks to block extradition of the offenders on the basis of Section 5, subsection E of the extradition treaty between the 2 states. This treaty allows extradition to be blocked for crimes, and I quote, of a political character. However, it is silent as to the definition of this term. Agents for the applicant have sought to rely solely upon alleged state practice with respect to the suppression of terrorism in interpreting this political offence exception. Would Your Excellencies prefer me to address this first, or would you prefer me to turn instead to an examination of the Vienna Convention on the Law of Treaties and customary international law as it exists already with respect to extradition and the political offence exception?
As you wish, Counsel, but why don't you begin with the first?
With respect to terrorism, Your Excellencies? Your Excellencies, agents for the applicant sought to force Filova to extradite, even apart from without proving that there is the political offence exception not being made out, on the grounds that Filova is under some obligation to suppress terrorism, and that as a necessary corollary, it may not refuse the extradition request. However, agents for the applicant have adduced only 2 methods of state practice to show what they allege to be the state of the law as at 1993, when the extradition request was placed by Ercola to Filova. The first of these, referred to in their memorial, is the European Convention on the Suppression of Terrorism. Now, Your Excellencies, while it is conceded that this treaty does allow a state, in some circumstances, never to refuse extradition for crimes which are of a terrorist character, may I point this court to Article 13 of this convention, which specifically states that a state may reserve to itself the right to refuse extradition, and I quote, for an offence which it considers to be a political offence, an offence connected with a political offence, or an offence inspired by political motives, provided it takes several factors into account. In fact, over half of the states signatory to this convention have made a reservation refusing to recognise the existence of an international law right or duty to extradite automatically for crimes which are allegedly terrorist. That is, even in a convention, a regional convention, which specifically addresses this issue, over half of the signatory states have refused to submit themselves to the principle which applicants allege is a principle of customary international law. Turning to the second source to which the applicants referred, and this is the Inter-American Convention on Extradition, again referred to in their memorial. This convention also contains a provision with respect to terrorism and extradition, and I may quote from Article 5 that no provision of this convention shall preclude extradition regulated by a treaty or convention for an offence which is, and I quote again, an offence which is in or is in a category of offences which international law requires a state to either prosecute or extradite the person sought. It is submitted that customary international law recognises only very few offences to be of this character, and in fact has limited international crimes or crimes for which the requested state must either extradite or prosecute to the specific crimes with respect to the unlawful seizure of aircraft in the Hague Convention of 1970, the Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation of 1971, the Montreal Convention, and the International Convention Against the Taking of Hostages of 1979. That is, even if we're to accept the contention of the applicants that this treaty, this Inter-American Regional Treaty, is representative of customary international law, the only offences of terrorism that it allows a state to request extradition for, in spite of a political offence exception, are those very specific acts upon which the international community has already determined are offences which are crimes against the international order. That is, even using the applicant's own materials, it shows a lack of consensus by states party to these treaties that there may be some overriding terrorism exception to the political offence exception. This lack of consensus was also evident in those very treaties which designated these crimes as acts of international terrorism, and the travaux preparatoires to all of those conventions show that no consensus could be reached to place into the text of the convention a provision, as requested by some Western states, requiring extradition automatically for any terrorist offence, even where there is a political offence exception in force. Thus, contrary to the submissions of the applicant, there is no rule of general customary international law requiring automatic extradition of allegedly terrorist offences, where there is a political offence exception in force, even for those very crimes which the international community has unambiguously defined as terroristic, let alone offences such as those alleged here, which are at most dubiously terroristic. Your Excellencies, it is submitted by Filova that this has been reflected in international practice as recently as the 31st of January this year in the Security Council's resolution with respect to Sudan, requiring it to extradite offenders who attempted to take the life of the President of Egypt, an internationally protected person and thus an internationally recognised act of terrorism, which the Sudan attempted to refuse extradition from and would otherwise be able to refuse extradition were it not for the Security Council's resolution expressly to reverse and override this decision. Would Your Excellencies like me to turn to the interpretation of the Vienna Convention and the political offence exception?
How does the General Assembly override, if I understood you correctly, the extradition treaty?
Your Excellency, it wasn't the General Assembly, it was the Security Council that overrode and it was accepted by this court in the case concerning the interpretation and application of the 1971 Montreal Convention, which expressly recognised that the Security Council may override a right of a state which would otherwise be a sovereign right.
I'm not sure I have understood exactly which standard you want this court to apply in terms of the political exception. If I understand the law correctly, there are basically three standards. Which one of the three do you want this court to apply?
Your Excellency, it is Filova's submission that in fact this court ought not require it to impose any specific test at all. It is in fact Filova's contention that extradition is an entirely sovereign decision, and as such Filova should be entitled to invoke any test it sees fit. That is, we are not even pressing for a particular test to be applied. If I may point this court to the joint statement by 4 judges in the Lockerbie case to which I referred earlier. These judges stated, and I quote, that insofar as general international law is concerned, extradition is a sovereign decision of the requested state, which is never under an obligation to carry it out. Therefore, while the extradition treaty between Ercola and Filova as lex specialis may derogate from this general international law, where it is silent, as in this case, we must return to the underlying principle, which is that, in fact, extradition is a sovereign decision of the requested state. And indeed, this has been mirrored in the decisions of municipal courts, such as the courts of the United States in the case of Quinn and Robertson, and in the court of Chile in the case of Inre Campora. However, Your Excellency, the second subpoint of this submission is that even if we are to accept one of these tests, that Filova may block extradition on the basis of any one of these tests. The 3 tests are, as adverted to by agent for the applicant, the predominance or civil law test, the political incidence or common law test, and the French injured rights test. Turning firstly to the civil law predominance test, it is submitted that this test imposes a requirement that where an offence is not purely a political offence or purely a common offence, but, as the court is concerned here, an offence which is an otherwise common offence with some political character, that is a complex offence or otherwise known as a relative political offence. When the court is dealing with such an offence, the political element must predominate over the common element in order for a state validly to characterise it as a political offence and thus invoke the political offence exception. It is submitted that the test that is used is to look at the act which was done and the purpose for which the act was done, and to see if there is a proportionate or proportionality between the two. It is submitted here that firstly, the rights which are being infringed and for which ILSA are acting are, firstly, the right to self-determination, which, as referred to by my co-agent, this court last year in the case concerning East Timor recognised as a fundamental principle of international law, coupled with the abuses of the minority rights of the itics in Ercola, that is, the rights with respect to religion and language. When those rights are examined and the content and the abuse of these is seen to be grave, when viewed against the level of violence used, it is submitted that the level of violence is in proportion to these rights. Firstly, because the stock exchange was targeted on a public holiday, and adequate notice was provided of the train station bombings, showing throughout an intention not to take any life, and that the life which was lost, unfortunately, was unforeseeable both to Filova and Ercola, as in the first case, the homeless people who were unfortunately killed had established, and I quote from the compromis, unnoticed makeshift accommodation in the rear of the stock exchange, and in the second case, when one of the train station devices exploded, killing the defusing bomb officer. In both cases, the deaths were unforeseen and unintentional, and it may be seen that the act of violence which was carried out was merely an attempt to carry out property damage, given that they bombed a building which was closed on a public holiday, and that the others were directed against train stations with adequate notice to allow them to be evacuated, and also to allow authorities to find the device. Further, when viewed against the light of 2 independent, non-governmental organisations who determined that the crackdown upon ILSA was, and I quote, unwarranted, and since most especially all legitimate means had been tried by the ILSA organisation and had been thwarted by the Ercolan government in the form of refusing to allow ILSA to stand and play any part in the democratic process, as a result, the grave abuses and the extremely large content of the rights which were infringed, when weighed against the small nature of the violence which was used and, unfortunately, the few number of deaths, shows that the acts are clearly proportionate.
Counsel, I'm troubled by one point you made. You began at a certain point describing the act, the death that took place as being unforeseeable. When you got to the bomb diffusing officer, it changed from unforeseeable to unintentional, and accepting that the death was not intentionally inflicted. Is it not certainly foreseeable that if you plant a bomb at a railroad station, if the police notice of it, that they're likely to try and defuse it, and somebody might get blown?
certainly, Your Excellency, and even if it is conceded that, in fact, it was foreseeable that ILSA may cause some death, it is still submitted that the level of death which would be caused would be minor in comparison with the grave rights and the grave abuses of the rights which had occurred, and that even if ILSA were branded with some culpa for their acts, it is still within the modicum of proportionality allowed by the test and still allows their offences to be classed as political.
Where are we going to find the number of deaths that are acceptable?
Your Excellency, it is not for this court to pronounce upon what is an acceptable number of deaths. It is submitted that any is in fact unfortunate. However, it is the nature of violent struggles and uprisings, and it has been consistently underlying the political offence exception, that some violence and some death always occurs in an attempt to overthrow or change a political institution, and that while loss of life is extremely regrettable, a small loss of life may, when seen in the wider context of the political uprising, be seen as legitimate. For example, perhaps, in the case of the French Revolution or the American War of Independence. Turning to the second test to which I adverted earlier, that is the test of the common law countries of political incidents. This test, espoused in the case of Kessedjian, has two limbs. Firstly, that there must be a political uprising or disturbance, and secondly, that the act performed must be incidental to and in furtherance of that uprising. It is submitted that the case put forward by the applicants, the case of Inri Atta, a case decided in the United States, is eminently distinguishable from the present, in that, in the Atta case, the violence used was directed specifically against innocent civilians, in that the perpetrator firebombed a civilian bus. It is submitted that here there was no intent to injure or kill any innocent civilians, and as I adverted to earlier, that the loss of life that occurred was unintentional and unforeseen and entirely regrettable. Similarly, if I may refer this court to another American case, the case of Ian, which again involved a bombing. In that case, the bombing placed in the town of Tiberias in Israel was again specifically, to quote from the court, designed to endanger and to kill innocent civilians, and as such is distinguishable from the present case, and that those two cases where extradition was granted are not the same as the circumstances with which this court is currently faced. As a result, on the second test, it is submitted Filova may also block extradition on the grounds of the political offence exception. Turning to the third test, which is the French injured rights test, it is submitted that this test, set out in the case of Giovanni Gatti, refers the court to the nature of the rights injured, and it is submitted that here the nature of the rights injured are those of the government, in that ILSA is attempting to overthrow and replace the political structure, and that therefore the acts are in furtherance of the political motive and are also therefore validly characterisable as political offences. Therefore, Your Excellencies, it is submitted that firstly, on any of the three tests available in the municipal legal systems of civilised countries, that Filova may invoke validly the political offence exception for the current crimes and thus may refuse extradition, but that even if we accept the proposition advanced by the applicant that there is some overriding duty stemming from a suppression of terrorism, that even then there is insufficient state practice to fulfil or to create a rule of customary international law which would require Filova otherwise to extradite, even though prima facie the political offence exception may be made out. It is therefore submitted that Filova is not under any obligation to surrender the fugitives. Turning then to my second submission with respect to privacy and the ESPRI database. Agents for the applicant sought to rely upon a right to privacy in international law. It is submitted that while qualified rights to privacy are contained in some conventions, such as the European Convention on Human Rights, the Inter-American Convention on Human Rights, or the ICCPR, Ercola is a party to none of these conventions and thus may not oppose any of these conventional rights to Filova. Therefore, Ercola must establish some customary form, some customary right of international law in order to oppose it to Filova. Although this was not pressed arguendo, on pages 23 to 24 of their memorial, the applicants seek to rely upon a right to privacy as contained in the Universal Declaration of Human Rights, Article 12, coupled with Articles 55 and 56, which they allege transforms the right of privacy from one of merely being a declaratory status to one being a right of customary international law. To quote from the statement of the chairperson who drafted the Universal Declaration of Human Rights, Mrs. Eleanor Roosevelt, she stated that this document is, and I quote, not a treaty. It is not an international agreement. It is not and does not purport to be a statement of law or of legal obligation. And while it is true that the rights contained in the Declaration may become rights of customary international law, it is submitted that the process as outlined by this court in the North Sea Continental Shelf case must be fulfilled in that there must be the consistent and uniform state practice accompanied by the requisite opinio juris to to convert these rights to ones of international law. It is submitted that while some of the provisions, such as Article 5 of the Universal Declaration with respect to torture, have become rights of customary international law, Filova denies that the right to privacy has become a right of customary international law. Firstly, the requisite state practice is lacking. The right is not recognised in any common law jurisdiction of the world apart from the United States. It is absent from the Canadian Charter of Rights and Freedoms. It is absent in the New Zealand Bill of Rights. It is expressly, from the highest court of the land in the United Kingdom, stated not to be a right known to the common law of England. Likewise, it is not a right found in Australia. As such, the municipal legal systems of the world, the common law half, only one state has a right to privacy in its own domestic law or in its constitution. Turning to the civil law countries, which constitute the other half of civilised legal systems, the right to privacy does exist in some of these jurisdictions, such as, for example, France, in Article 9, which was proclaimed on July the 17th, 1970. And while this may perhaps amount to a right to privacy sufficient to be infringed by the alleged case at hand, other countries, such as Japan or Italy or Germany, do not have sufficient rights to privacy to justify an invasion of the type alleged by Ercola. It is therefore submitted that there is no state practice showing that there is a right to privacy recognised in the municipal legal systems of civilised countries. Likewise, there are no conventions with respect to respecting the right to privacy, unlike conventions, for example, which proclaim against apartheid or against discrimination against women or against cruel and unusual punishment. And so there is no opinio juris as well. Thus, both elements required to transform the right to privacy from merely a declaratory right to a right of customary international law are lacking. As such, there is no right, no breach of an international obligation may result if there is no right, and the first element of state responsibility, as outlined by this court's predecessor in the Chorzów factory case, is not made out. However, the second subpoint of this submission is that even if Filova is to concede that there is some right to privacy which Ercola firstly may oppose to Filova, and that secondly, even if there is some evidence showing that Filova is responsible for the breach of this right, that there is no right for Ercola to demand damages as reparation for this right. This is because any damage suffered as a result of an invasion of privacy is necessarily a moral damage. It is damage which is mental or humiliation or shame, suffering, degradation, or with respect to reputation. It is settled in international law that material damage, such as death or personal injury, or pecuniary damage, such as with respect to contracts or property, may be compensable in damages. But international arbitral practice has only recognised that moral injuries are compensable when they occur in conjunction with either a material or a pecuniary loss. And so, for example, in the Lusitania case, the leading example of a case which awarded moral damages, the foundational wrong upon which the moral damages occurred was in fact a death caused by the sinking of the ship. Likewise, in the Janes case, damages were awarded for moral damages. Your Excellencies, I see my time has expired. May I be permitted to briefly to... Thank you. And while other international practices have recognised moral injuries as compensable, it has only been where there has been an infringement concurrently of a material or pecuniary right. Your Excellencies, if you do not wish me to address the question of return of the database, that is covered in pages 15 to 20 of our memorial. Would you like me to summarise it briefly, arguendo?
Very briefly. I'll give you half a minute.
Your Excellencies, it is submitted that in fact, firstly, as argued by the applicants in their memorial on page 20, there is no unjust enrichment at hand here requiring Filova to return the database, as Ercola has not been deprived of the database, and deprivation is the foundation of unjust enrichment. And that secondly, Filova has two grounds in international law upon which to claim the database. Firstly, as evidence exercising its sovereign powers of arrest and gathering evidence, and secondly, in the form of intelligence gathering in its own territory, where it has not infringed the territorial sovereignty of any other state. Your Excellencies, as my time has expired, that concludes my submissions.
Thank you very much, Counsel. We now call upon Counsel for the applicant for their rebuttal.
Your Excellencies, the gist of the respondents' case is this. They have tried to justify their intervention by claiming that the Yitiks' rights, their human rights, have been violated in Ercola. And to support this, they have raised two facts. Before that, Your Excellencies, I would like to point out that in the compromis, it was stated that there have been no substantiated allegations of the denial of basic freedoms to any group within Ercola, except these two facts, which the respondents have raised. Firstly, they have said that the Yitiks have been denied a right to religion. Now, Your Excellencies, all they've been denied on the compromis is that they do not get paid leave on religious holidays. Your Excellencies, this does not derogate from their right to worship as they choose, to teach their religion as they choose. Secondly, Your Excellencies, they have pointed to the policy that the official language of Ercola is the language of the majority, and they have called this, again, a derogation of the human rights of the Yitiks. Again, Your Excellencies, there are many nations around the world which consist of many ethnic minorities, and it is only practical that the language of the majority be chosen as the official language. This does not in any way derogate from the right of the Yitiks to speak the Yitik language, to teach the Yitik language as they choose. Your Excellency, as the respondents have said, the crux of the issue today is about self-determination. Which path do we choose to go to greater peace? What the respondents have suggested is that ethnic minorities, Your Excellencies, have a right to self-determination and secession despite the fact that they come within an independent sovereign state. Your Excellencies, we have submitted that this is not the law, and this would lead to chaos and instability and infinite divisibility. Your Excellency, every nation in the world has different ethnic minorities. The answer is not in allowing these ethnic groups to separate. The answer is in recognizing these differences between these ethnic groups and respecting these differences by protecting their minority rights. These, Your Excellencies, we have done in Ercola. Your Excellencies, I finish my submissions. Thank you.
Thank you very much. I call on Counsel for the respondent. Sir rebuttal.
Mr. President, members of the Court, Filova submits that agents of the applicant have confused human rights with minority rights. Certainly, it is not our contention that the Yitiks have been denied certain rights. Human rights require only that they be free from coercion, that states not prevent them actively from exercising their religious practices. Minority rights, however, require something more, and in the words of the Declaration on the Rights of Persons Belonging to Minorities, states must protect their existence and their peculiar characteristics and shall encourage conditions for the promotion of that identity. Secondly, agents of the applicant claim that we're going to create a situation of infinite indivisibility. They've not raised any evidence that this is the case, and if I may refer the Court to a recent study of self-determination groups in a book called Self-Determination in the New World Order, which identifies only 99 self-determination movements in the world today, which is some way short of an infinite indivisibility.
Thank you, Counsel. I wish to thank both teams for those excellent arguments. The Court will now retire to deliberate and will return when it has concluded its deliberations.
The Honourable Court is now adjourned.
Please be seated. May I first call on Judge Kessedjian to make a few remarks.
Thank you, Mr. President. Let me start first by my most sincere congratulations to both teams. I have been very impressed by your presentations, both in form and in substance. Let me start more personal remarks for the two persons who had the most difficult time this afternoon. That is, the two persons who didn't speak on the team. And I'm saying that because I know how hard it is when you have been involved since the beginning in the preparation of everything, not to be able to stand and actually advocate your case. And you have been both very good. I've been looking at you. You have been standing still with no remarks, with no sense of exasperation, which is very good. And I congratulate you for that. And it's, again, very, very difficult, I know, by experience. For the four of you who had a chance to speak this afternoon, I must say that I was very impressed by the fact that you were able to, I would say, and I'm missing the English word there, to overcome the stress, certainly the fear, although I think we are quite a nice court, and to actually be able to go back almost immediately to your point and your argument after some tough questions from the court. So I think that's very good. What I would like to tell you and the rest of the students in this room who are preparing for a career of advocating or trial attorney, or whatever I think is your profession in the future in the legal field, that one thing you always have to do, and I think you were very good at that this afternoon, is to really constantly have in mind what is the person in front of me expecting from me? What is the person in front of me understanding of what I'm saying? What is the person in front of me really wants me to go into and try to understand the psychology of that person? That's a key, I think, position to have when you are addressing a crowd of any sort, whether you become a politician or whether you are a professor in an auditorium, or whether you have to simply address a seminar or whatever. And in order to do that, the substance is, of course, very, very important. But when you have a difficult case, when you have your position is sometimes a weak position, and sometimes we have to argue weak positions, or the positions that are not in the mainstream, positions that are difficult to advocate, then the form is even more important. And the form is mostly the voice and the hands. And I know I have problems with both of them, so I dare giving you some advice, but perhaps I'm not the best person for that. The voice, it's very, very important that you make sure you modulate the tone of your speech. There is nothing more boring in any single event that somebody who addresses an audience with absolutely the same tone from the first minute he or she starts to the end of the speech. And inevitably, 50% of the crowd will be asleep by the end of the speech. So you really have to kind of act that, addressing a crowd is really some kind of actor's skills. And if you have not done so, perhaps a little bit of theater acting may be helpful. The second thing is the hands. And I know sometimes I don't know what to do with my hands, and it's very difficult, particularly when you stand on a podium, to know exactly what to do with your hands. And I think I was particularly impressed by the four of you this afternoon because you had exactly the right gesture. You had exactly the convincing gesture at the moment when it was necessary for your speech. So it's really good. And you have to, and I address every other person in the crowd, you really have to think about that because sometimes it's distracting the person who listens to you to look at the gesture you are making. So you have to be very careful. In closing, again, I want to repeat that I really enjoyed hearing you this afternoon, and I wish you really all the best. And I address all my congratulations, not only for the organization of this Jessup, which seems to be every year better and better, and I wish all the teams that have been competing all the best for their future career.
Thank you so much. Judge Brouwer.
This has been a wonderful performance this afternoon. I would recommend to the management of ILSA that it consider trying to sell tickets in the future because I'm sure it would be a successful fundraising venture. I remarked to Judge Schwebel when we were deliberating the case, do you know that the issues covered in 45 minutes per side this afternoon are allotted days for argument at the International Court of Justice? There are time limits in the sense that a schedule is set, but literally days are available to argue issues of the complexity and so numerous as you've had in this case, and to compress that in any way, shape, or form into 45 minutes on a side is a virtually impossible task, and you've done extraordinarily well. I should like, to the extent I can, to assure you, as I'm sure you appreciate, that we have approached our task with a special conscientiousness. Judge Schwebel has been on the bench at the International Court of Justice now for 15 years. I've had some experience in another international tribunal myself, and we've both had experience as advocates. At this point, it seems comparatively easy to deal with high issues of state and hundreds of millions of dollars in disputes that come before such tribunals. None of those put quite as fine a point on the importance of our task as this does, because you all have made a tremendous investment of yourselves, of your spirit, and of your time, and of your passion in this. And we've all been the beneficiaries of it. As to the aspects of advocacy, Judge Kessedjian has made points which should certainly be well taken. They're quite accurate in my experience. I would emphasize, and that was well demonstrated this afternoon on both sides, the critical importance of conceding points, whether on the law or the facts when they arise. In the vernacular of the poker player, and there's a country and western song along these lines, you have to know when to hold and when to fold. And you, on both sides, demonstrated a very keen understanding of when to hold, and also, very important, when to fold. Your eye contact, in addition to the voice and the hands, eye contact in all forms of public speaking, in all forms where a voice is exercised for the purpose of seeking to convince the auditor of some proposition is absolutely critical, and you all did a marvelous job of that. Obviously, you would not have arrived at the finals without having mastered all of these aspects quite considerably, but I thought I might add that element to what Judge Kessedjian has said. You might have discerned from some of my questions a certain attention to facts, and it is sometimes the case, particularly in international proceedings, that the law is very much discussed and the facts are not so readily dealt with. And I obviously come from a tradition and an experience in which facts are important, and they are important in these international cases. And I think you all showed a very good ability to respond with the necessary laundry lists of the facts that applied in response to the question. Excuse me. To sum up, what is needed in advocacy is basically the power to convince. And you cannot convince unless you convey yourself a high degree of conviction of the truth and the validity of that which you are presenting. Many things go into that, but that is what it all adds up to. And you, on both sides, have been extraordinarily persuasive and convincing. I feel a little bit like the master gemologist at Garrard's in London, the jewelers who hold the royal patent, as it is said in London, to supply the royal family, and as though I had placed before me two perfect diamonds of identical caratage, and we're asked to make a decision as to which one goes into the ring for Her Majesty. You have really done a wonderful job this afternoon, and for the benefit of everyone else in the room, many of whom, if not most of whom, I am sure have been involved in the various rounds of the competition that led up today. These people who come before us this afternoon do all of you proud, because their performance reflects that it has been a tremendously high level of competition and undertaken not only with great skill, but with a wonderful spirit. I congratulate all of you.
Thank you so much. Well, my eloquent colleagues leave me with little to say. I would say that as cross-examination in the common law has been described as the greatest engine, the greatest means of getting at the truth, so the Jessup competition in international law may be the greatest means for bringing out a nascent talent in international law. The Jessup competition is a superb engine of legal education. I think we can all be confident that the very considerable time you've devoted to the competition is time very well invested in terms of your own training as international lawyers and the deepening of your knowledge as citizens of the world. And I may say, without any degree of exaggeration, that the quality of the arguments that I've heard today compare very favorably with the quality of the arguments heard in the International Court of Justice. Now, with that, I would like, on behalf of the court, to proceed to announce the best hour list. And I will say that we deliberated on this matter with a good deal of deliberation because, as Judge Brower has said, we felt we were looking at diamonds of very high quality. Nevertheless, it is the function of a judge to decide, and we have decided that the best hour list is Miss Lin Lee. Well, the task of deciding on the winning team was equally difficult and no less deliberated. Once again, we've perforce reached a decision, and we decide in favor of the respondents. Any team to reach these finals necessarily has demonstrated the greatest capacity and skill that has been demonstrated today, and in recognition of that demonstration, they will be presented with the runner-up prize. And please come forward for that. No, I'll just adjourn us all this stuff. Well, ladies and gentlemen, that brings to an end the 37th Jessup competition and this afternoon's proceedings, and the court would like to thank you for your attention and your enthusiasm and to wish you all well. The court stands adjourned.